Right. So, good afternoon, everyone. Welcome to this lunch seminar. Today, we're pleased to have our old friends, Carole, Professor Carole Petersen, and her husband, Charlie, both coming back to the campus, the university, to give a talk. Carole is no stranger to many of us here, so I'm not going to just introduce her in greater detail, except saying that she's now the Cadet Foundation Professor at law at the University of Hawaii. The topic is an exciting one: productive autonomy, the impact of a pandemic and the recent jurisprudence. So, without further ado, the floor is yours, Carole. Welcome back.
Thank you so much. It is always a joy to come back to Hong Kong U, and I know sometimes times are a little too interesting and you've been through a lot of ups and downs. But things are also interesting in the United States and a little terrifying politically right now because we are faced with the possibility of a second Trump administration, which could have huge repercussions for the topic of my talk today. Anyway, the first slide is entitled Comparative Approaches to Abortion. And I always like to start a talk about reproductive autonomy, explaining the differences in these approaches. In the US, people have typically talked about rights-based approaches. That's what Roe v. Wade, in theory, at least embraced. But most parts of the world actually don't necessarily take a rights-based approach to abortion. They take what I would call a public policy approach to abortion, where the legal system does not recognize a right to terminate a pregnancy. And in fact, the legal system often contains a general prohibition on abortion, but then it provides for exceptions. And sometimes the exceptions can be very broad, as in the British legal system, and Hong Kong law is basically very similar to the English model, where the doctors have quite a lot of discretion. Right? If two doctors certify that someone needs an abortion because of their health or even the well-being of their families, it could be mental health, it could be physical health, they can actually obtain an abortion fairly easily as long as the doctors are supportive. Or you can have a very narrow set of exceptions. And the best example of that right now is Poland. Poland used to at least have exceptions, not only to save the woman's life, but an exception where there was a fatal fetal disability, right? That was incompatible with life. They got rid of that recently. So, and people went to the streets to protest because the exceptions there are so narrow. So the reason I like to start with this is that's actually where my research started in this area ages ago in 1993. I published a chapter in a book edited by Ray Wax here, Essays in Legal Theory. And my article or chapter argued that the public policy approach was sort of inherently disrespectful of women because, you know, if you wanted an abortion under the English legal model or the Hong Kong model, you basically had to say, I can't manage this pregnancy, right? There's something wrong with me. It would not be enough to say, hey, I was raped and I don't want to carry this pregnancy. I can manage it. I'm a strong person, but I don't want to carry this pregnancy. You actually, in that scenario, would not be entitled to terminate the pregnancy. So in 1993, I was very critical of this. And I compared in the book chapter to the rights-based model in the US, which was already tenuous because Roe v. Wade, frankly, had been under attack for a while. Right from the start, it was under attack. But it had recently been upheld in a case called Casey v. Planned Parenthood v. Casey. And so at the time when I published that book, I was arguing for the rights-based approach. I have to say, with, some 30 years of thinking about it, I have a much more nuanced view of the differences between rights-based and public policy approaches. The rights-based approach has to be honest, been very bad for the United States, and not just for reproductive autonomy, but for the way we select federal judges, for example, because there are people in the United States who are so opposed to abortion that they really did engage in what we call single issue politics. The only issue that mattered was getting judges appointed to the federal bench who opposed Roe v. Wade. And so they would vote for presidential candidates on that basis. And it took a long time, but eventually they got what they wanted. And it has so skewed, I think, not only the politics in the United States, but also the process by which the US Senate approves the appointment of federal judges, that looking back on it, I think maybe we would have been better off in the United States if the Supreme Court had issued a decision that it was at least a lot less proscriptive. The Supreme Court could have, in Roe v. Wade, issued a decision saying, hey, the abortion law from Texas and Georgia violates women's constitutional rights, and it's not in force anymore. And we'll leave it to you state legislators to figure out how to comply, right? And maybe there would have been gradual law reform at the state level. There would have been more litigation. I think one of the problems with Roe v. Wade is that if you read the Roe v. Wade decision, it actually reads like a piece of legislation. Trimester 1, trimester 2, you can't do anything to regulate abortion in the first trimester. In the second trimester, you can regulate it to protect women's health. In the third trimester, you can actually prohibit it. If you read it, it reads actually almost more like a decision of the Standing Committee of the National People's Congress, right? Not so much an interpretation, but almost legislative. And that was one of the reasons it was criticized from the start, even from people, legal scholars who supported women's right to autonomy. Ruth Bader Ginsburg even criticized it as an academic and as a lawyer because she felt it was grounded too much in the gender-neutral right to privacy, the doctor-patient relationship, and not enough in women's right to equality and liberty. But looking back on it, I can understand why it was, because frankly, the plaintiffs in Roe v. Wade didn't even try to argue equal protection so much as doctor-patient right to privacy. And that's partly because they were probably recognizing that they were doing something that was quite dramatic. And so they were trying to ground it in a right that would be very accepted, they hoped, by many people in the United States. Now, more recently, of course, we've seen that Roe v. Wade was very vulnerable. I'm not going to spend too much time on the Dobbs decision in 2021, because I think a lot of you are probably already quite familiar with it, but I have published an article in the University of Hawaii's Law Review on it that I'm happy to give you if you're interested. In a nutshell, what happened is that the Casey decision in 1992 tried to put Roe v. Wade and the right to reproductive autonomy on a little broader foundation, not just doctor-patient privacy relationship, but what some scholars call the double helix of liberty and equality. The idea is that privacy, although it's an unenumerated right in the US Constitution, is inherent within the liberty, right, that is promised in the 14th Amendment, the substantive due clause in the 14th Amendment. And Justice Kennedy, who really struggled with abortion personally, but did not want to see Roe v. Wade overturned, he developed in the Casey decision this concept that you could uphold a right to abortion pre-viability. And the essential words are you cannot put an undue burden on a woman's decision to terminate a pregnancy pre-viability. But what was really interesting about the Casey decision is what justified it, and wasn't just the doctor-patient privacy relationship. There was much more language now about the burden of an unintended pregnancy on a woman and the personal sacrifice that's involved in carrying a pregnancy to term. And so there was an effort, I think, to put it on more stable grounds jurisprudentially. And Justice Kennedy further developed this concept of the intertwined rights of liberty and privacy in a trilogy of cases that advanced the rights of the LGBT community. So we saw the Lawrence case, which struck down Texas's laws prohibiting same-sex relations, the Windsor case, and then finally the Obergefell case, which upheld the right to same-sex marriage. And we saw in those cases reliance on what Professor Tribe at Harvard called the double helix of liberty and equality. And at that time, I was really quite hopeful that reproductive autonomy as a constitutional right would survive. But as Ruth Bader Ginsburg pointed out once in a commentary, that double helix was never used as strongly by the Supreme Court in the context of abortion. And we saw certain decisions upholding state restrictions on abortion being upheld. And I do think it has something to do with the fact that Kennedy perhaps was never quite as supportive of women's right to reproductive autonomy as he was to other uses of this double helix. In any event, the really key thing is that although people thought there was now a new test for what is an unenumerated right, in fact, the Supreme Court never overruled a case called Washington v. Glucksberg, which was a case that essentially said that if an unenumerated right is going to be protected by the Due Process Clause in the 14th Amendment, it must be, and I'm going to quote the language because Alito used it so much in his opinion, it must be deeply rooted in the nation's history and really essential to the concept of ordered liberty. Now, that was considered to be a very strict test for an unenumerated right. And if it had been applied in the LGBT decisions, we probably wouldn't have had those decisions, right? Because a right to same-sex marriage, hard to say, was deeply rooted in the nation's history, right? The point of Justice Kennedy's approach was you couldn't just interpret those concepts of ordered liberty the way they would have been interpreted in the 1800s, because there were people who were subordinated then, women, gays and lesbians, people of color, and therefore you had to interpret the Due Process Clause in a way that gave those people equal citizenship. Now, as I said, a lot of people thought Washington v. Glucksberg is kind of a dead case now, but it was never overruled. And it came roaring back in the Dobbs decision. We suddenly see Justice Alito writing this opinion where he's harping on the fact that women didn't have a right to abortion when the 14th Amendment was adopted. And if you've had the displeasure of reading his decision, you'll see it's a very long decision because he has an appendix where he attached every single state statute that prohibited abortion when those post-Civil War amendments were adopted. So his point is, if all these states were prohibiting abortion by the time the Civil War ended, clearly a right to abortion was not deeply rooted in the country's tradition. He actually applied a very selective approach to history, and a number of historians have criticized him. And in this article, I talk a little bit about it. Basically, the fact is women in colonial America often practiced abortion. It was what we would call now self-managed abortion. It was common for midwives to advise women on herbs that could be grown and consumed if your period was late. They called them restoring the menses. They didn't call it abortion then. They said, oops, my period's late, better chew on that herb. And it didn't always work, but sometimes it did. Sometimes they could be a little bit poisonous. But the fact is, women were terminating pregnancies in the 1700s. And under the common law that we inherited from England, it really was not considered a crime pre-quickening, quickening being the term that was used then for when there was fetal movement that was discernible by the woman. It was a subjective test, right? Justice Alito kind of ignored all that history, and he ignored a lot of the motivations for those criminal statutes that arose in the 1800s. In essence, the American Medical Association, which was a new organization in the mid-1800s, wanted to wrestle control of reproductive functions from midwives, because traditionally women delivered with female midwives, and they were advised by female midwives on their pregnancy. It was when the American Medical Association was created and wanted to get control of that the anti-abortion movement started. And a particular doctor was very instrumental in pushing state legislatures to criminalize abortion. And if you read the pamphlets that he used, they were very sexist and actually also very racist, because often the argument as to why we had to stop women from terminating their pregnancies was that the white Protestant women aren't having enough babies anymore, and we're going to be overwhelmed by those Catholic immigrants coming from Italy. Seriously, there was a lot of that. And so if you really apply Justice Kennedy's view of the Due Process Clause, you would have to take that into account, right? And realize that those state legislatures, they didn't have female representation. Women did not have the right to vote, right? It really needed to be updated so as to give women equal citizenship. Justice Alito saw no reason for doing that. The Equal Protection Clause was not even argued by the people who were trying to defend Roe v. Wade in the Dobbs case, but some amicus briefs did try to argue it. And the idea being that even if you cannot justify a right to reproductive autonomy under the Due Process Clause, you should under the Equal Protection Clause, because it's essential to women's equal citizenship. And once again, you could see strains of this in the Planned Parenthood v. Casey decision. However, Alito just pushed that away in about a paragraph. And it's a worrying paragraph because he makes the point that maybe women aren't really a minority that needs protection anymore. And he quotes the fact that women now vote in the United States at greater rates than men. And some people have actually thought that he's getting ready to declare that we don't need even intermediate scrutiny when scrutinizing a law that just appears to discriminate on the grounds of sex, that we should just use rational basis. But that's just a small part of his opinion. The parts of his opinion that have gotten many people very worried are, well, really not so much his opinion, but Thomas's concurring opinion, are the parts where Thomas claims we have to go back and look at all of our substantive due process jurisprudence and revisit it now. And that's why the LGBT movement is very concerned that some of those decisions might be overturned. Personally, I don't think so, because Alito and Kavanaugh were very careful to say we're really only talking about abortion here, and to differentiate between those lines of cases on the basis that in abortion we're talking about the existence, of another being. And that is one of the reasons that I think the LGBT community probably doesn't have to be so worried. But it's also another reason that I think we're not done yet with abortion and Justice Alito. There are more cases that will come. Kavanaugh's opinion saying, oh, the Supreme Court's getting out of the regulation of abortion, we're leaving it to the states, is total nonsense. There's a case that's going to be argued before the Supreme Court on the 26th of March that I'll tell you about later. We're going to have state conflicts coming back, but we're also going to eventually probably have a debate about fetal personhood. And you have probably heard that a judge in Alabama argued that a fertilized egg in a petri dish is an extrauterine child, right? That has full personhood rights. Needless to say, the Republicans are thinking, oops, that was more than we expected, at least the mainstream Republicans. But there are people who are pushing fetal personhood. So we're not done yet with knowing how far Alito means to take that. Okay, that's all I'm going to say about Dobbs right now. And I want to talk about something that has actually decreased the impact of Dobbs. And this is what I meant in the elevator when I said you're going to hear some positive news in this presentation as well. Abortion pills are now responsible for more than half of the abortions in the United States. And that is also true outside the United States now. And the best protocol for what we call medication abortion are two drugs which essentially mimic an early miscarriage. First, you take a drug that stops the hormone, which is necessary for the pregnancy to develop. That's mifepristone. And then 24 to 48 hours later, you take misoprostol, which causes uterine contractions. And actually, that second drug can bring about a miscarriage or abortion, even without the first drug. But it's not quite as effective, and it's a little more traumatic physically. Now, medication abortion has been shown to be very effective. It's really only approved by the US Food and Drug Administration up through 10 weeks. But there's a lot of research outside the US to show that it's effective at least through 11 weeks. It's also safer than the surgical procedure because it's not invasive. Not all women will choose it because it does mean you are going to have bleeding and you're not going to be, and it's not going to be finished as quickly as it would be if it's a surgical procedure. But a lot of women would prefer it, even in places where surgical abortion is completely legal, because you can manage it at your home in privacy. You can have your spouse or your best friend with you to comfort you if you need comfort, and it's private. Which means, if you're in a place where there are protesters outside every abortion clinic, you don't have to run that gamut, right? You don't have to take time off work, which for many poor women is almost impossible because they can't get paid leave for that. You don't have to find someone to look after your children, right? So you may be a little bit under the weather for a few days, but it's in some ways much easier for many women to have a medication abortion. Now, in a lot of countries and in a lot of states now in the US, the governments are trying to prevent women from getting access to these pills. But I can tell you it's very, very difficult, right? Because you can mail these pills. And as I'll explain a little later, there are NGOs all over the world that are offering telemedicine help, right? And they'll screen you to make sure that you can have a medication abortion, because you shouldn't try this if you have an ectopic pregnancy. You absolutely need surgery in those situations. And there are some medical conditions that would not be appropriate for a medication abortion, right? And so they will screen you, and then they will write the prescription, and the pills will be mailed to you from a pharmacy in India in a brown paper envelope, right? Almost impossible to police. Abortion pills are also being smuggled across borders all the time and sold on the black market. There's a feminist organization that packs them in Mexico and inside a little box with jewelry on top and a little tissue paper to disguise it, but also to give the person a little present, right? I mean, women are getting organized and delivering these abortion pills. Now, prior to the pandemic, a lot of governments placed pretty onerous restrictions on abortion pills, even if abortion was legal. And I think these restrictions initially were quite well-intentioned because this was a new medication, and they wanted to make sure that any side effects were monitored. So you had to go to a doctor or a clinic. You had to have an in-person visit, a pelvic examination to make sure you don't have an ectopic pregnancy. You often had to go back for a follow-up visit. But the problem with that is it often slowed access to the abortion pills, which meant that women were having the abortions later in the pregnancy because of the time necessary to get that appointment. And frankly, the research shows that any benefits that might be obtained from that in-person screening are actually greatly outweighed by the disadvantages of having the abortion another week or two later in pregnancy, because with every week it becomes a more traumatic process. So you're actually better off, and I can give you lots of studies that will support this, that you are much better off having easier access to the pills and just doing the screening process over a phone call or a telemedicine appointment. So the pandemic greatly affected a lot of governments thinking about access to abortion pills. The demand for abortion care probably went up during the pandemic. I've read some conflicting studies about this, but there are a lot of reasons why unintended pregnancies went up. First of all, there were a lot of supply chain problems with contraception. A lot of the contraceptive medicines that you need came out of countries like India, and there were real supply chain interruptions. Often there were even bans on exporting certain drugs because there was concerns, right, about shortages of medicines during COVID and just the natural supply chain problems we had. Women were spending a lot more time at home. And while you might think that leads to less pregnancy, actually, some studies show it led to more. And sometimes pregnancies that resulted from sexual abuse because women were stuck at home with abusers more. And then there's the other reason, why there was an increased demand for abortion care. And that is, frankly, during COVID, a lot of women had increased income insecurity. They were out of work, or they might have been sick with COVID. And so the idea of carrying a pregnancy to term became very challenging. Now, the problem was that a lot of governments didn't see that abortion care was, in fact, an essential service. And so during COVID, in a lot of states in the United States, particularly in certain anti-abortion states, the governors simply said, all abortion clinics shut down. You're a non-essential service, right? Ignoring the fact that it's a really time-sensitive service. And then, of course, women also had difficulties traveling. So if a woman was in a jurisdiction, whether it be in the United States or elsewhere, where abortion is very hard to get, they couldn't travel across borders so easily during COVID to find a place where abortion was easier to get. Now, fortunately, some governments did recognize the need to relax restrictions on abortion pills. The US federal government did under the Biden administration. The FDA announced a certain relaxation in the restrictions on abortion pills so that you didn't have to have an in-person visit, right? And by this time anyway, the FDA in the United States had also extended the time. It used to be you could only get the abortion pill for 7 weeks pregnancy, which is very early. By the time the pandemic rolled around, they had expanded it to 10 weeks. So 10 weeks, and you could use the telemedicine abortion appointment. The UK government, the British government did similar things, and a number of governments in Europe did that as well. Now, the advantage of this is it provided all sorts of data, right? The World Health Organization got involved in this effort. They actually published guidelines for what they call self-managed abortions. And I know that might sound really awful. If you think of a self-managed abortion as a hanger, coat hanger and bleeding to death, it sounds really awful. But actually, self-managed abortions now are very safe as long as it's an early pregnancy and you have screened yourself to make sure you don't have an ectopic pregnancy. So all of a sudden during COVID, we had this incredible trove of information, and there are tons of studies that have been done with thousands of cases where women have reported very few side effects, very high rate of success, and very little rate of a need for aftercare, right? Occasionally, women will seek aftercare, maybe because the bleeding doesn't stop as quickly as they expect. But all the studies I have read said that there's absolutely no deaths that can be attributable to the use of abortion pills. Not one death in 23 years that they've been studying this. Contrast that to Tylenol, which is an over-the-counter medicine, Panadol in Hong Kong, I think. There are a lot more deaths attributable to that, right? This is actually a very safe drug that probably should be available simply over the counter. They're not available generally over the counter anymore, but if you are tech savvy and you have a credit card, you can get it really easily. You don't necessarily have to go through the official healthcare system to get it. I've just cited a few examples of the NGOs around the world. Women on Web is one of the biggest one, and they offer services in 20 different languages. There's a group in Argentina that serves women in South and Central America. There's a Mama network in Africa that provides phone and other services to get the pills to people who need them. In the United States, there are two that have become very prominent since Dobbs was decided, Aid Access and Plan C. They give really detailed advice on how to use what are called in the US mail forwarding services, where you can order the pills to be delivered to a state where abortion is still legal, and then it's forwarded to you. Or you can have a friend order it for you. I mean, there are all sorts of ways. And these NGOs also offer very detailed advice on how to avoid detection. So, for example, the abortion pills can work in two ways. They can be inserted in the vagina or they can be put under the tongue. They're very careful to tell you to put them under your tongue because they will dissolve completely then. And if you do need to go to a clinic or hospital for some aftercare, it will be impossible for any doctor to tell the difference clinically between a spontaneous miscarriage and an abortion that was induced by pills. If you put the pills in your vagina, there might be residual evidence. And so that's the kind of advice that's being given. And as a result, if you're a tech-savvy woman in good health who doesn't have an ectopic pregnancy and you get yourself organized in, the first 10 weeks of pregnancy, the Dobbs decision in the US is probably not having much effect on you. And if you're in Poland or some other countries where abortion is still prohibited, you are probably also increasingly getting access to these pills, either through the internet or through some black market provider, right? I looked at a study of Indonesia, for example. Websites pop up, the government tries to shut them down, they pop up again. I'm not saying it's as good as being able to buy them in a pharmacy, because sometimes you might get scammed and you might not get the right medication. But the fact is, the rate of abortion in early pregnancy is increasingly not being affected by these laws, right? So there have been attempts to stop women from getting these drugs. Brazil is an example. Brazil is actually the country where women figured out that misoprostol, the second drug in that protocol, will bring about an abortion. And in the beginning, that drug was really cheap and you could get it in any pharmacy quite easily. And then the government found out women were using it for abortions and they started to strictly curtail the production and distribution of this drug. But women are getting it on the black market now. Spain, they actually tried to shut down the website of Women on Web, and Women on Web sued them and won, right, under access to information, freedom of expression. In the USA, this is the case that's going to the Supreme Court on Tuesday. Alliance of Hippocratic Medicine versus Food and Drug Administration, the FDA. Now, this is an organization, the plaintiffs, that didn't exist not that many years ago. It was formed for the explicit purpose of trying to litigate, right, to prevent women from having abortions. And this organization is an organization of doctors, primarily, who claim that they are being harmed by the FDA's approval of the first drug, mifepristone, right? And their argument is that under the Administrative Procedures Act in the United States, that the FDA acted unlawfully over 20 years ago when it approved this drug, and that they didn't do enough studies to make sure that it was really safe for women. Now, why would these doctors who do not practice abortion have standing? For those of you who understand, legal standing, they claim that they are harmed by the approval of this drug because they work, some of them, in emergency rooms, and they might have to provide aftercare to a woman who takes this drug and then shows up and they have to complete the abortion for her, which is against their principles. And that's one of the arguments they make on standing. It is a very weak argument on standing. And this case might ultimately be thrown out by the Supreme Court just on the basis of standing. But so far, they've managed to be somewhat successful. First of all, they filed it in a federal district court in northern Texas, where there's one particular judge who they knew would get that case if they filed there. And he is a former lawyer for anti-abortion groups, a Trump appointee. So he found a way, in his opinion, to hold that, yes, they all have standing. And he quoted from all sorts of discredited studies to say that these abortion pills are very, very unsafe and we have to stop them. And the FDA acted unlawfully. And he actually, issued basically a decision that said the FDA's approval is set aside, no effect. And everybody was in a panic that, oh my God, right? We're not going to have access to abortion pills. And of course, he has the power as a federal district judge to issue a nationwide injunction. So, of course, the US government appealed. It went to the Fifth Circuit Court of Appeals. We have these intermediate courts of appeals around the US. Fifth Circuit Court of Appeals is also very conservative. But it partly reversed him. It said, hey, you're kind of out of time to challenge the approval that occurred more than 20 years ago. But they did uphold his decision, setting aside the FDA's decisions along the way, one in 2015 or 16, and then one in 2021 during the pandemic, relaxing the restrictions on access to this drug. So if that order by the Fifth Circuit were in force right now, we would be back to the days where you need an in-person consultation with a doctor. It would have been much harder to get the abortion pills. It's not in place right now because the US Supreme Court granted an emergency stay when the Biden administration appealed. So mifepristone is still available. And even if it becomes unavailable, medication abortion will still occur in the US. It'll simply occur with the second drug. But as I said before, that's a little less effective and a little more traumatic for the woman. But of course, a lot of Republicans wouldn't mind that. Now, this is, I put March 25. That's a typo. It should be March 26. Oral arguments are scheduled. And I think it's going to be really interesting. If you want to log on to the Supreme Court's website, you can listen, or you can listen to a recording later. I think it'll be interesting because the Supreme Court seems so confident in 2021 that this is the last time we're going to have to decide a case about abortion. Back to the states, nothing to do with us anymore. Well, here it is, back pretty quickly, right? And I also think that the Supreme Court realized they had to take the case. So the US Supreme Court is what we call a certiorari case court, which means it doesn't have to hear every appeal that's filed. But there was already a circuit split getting ready to develop. And this is because while the anti-abortion groups were filing this case in northern Texas, a group of states that are liberal and do provide legal abortion services were filing their own case in the Eastern District of the state of Washington, which is in the Ninth Circuit, much more liberal circuit. And they argued that the FDA is actually being too strict still in its controls on mifepristone, and that it should be a more liberal regime. And they got a preliminary injunction saying to the FDA, you can't do anything while we're hearing this case to make access to mifepristone any more difficult for women. So the FDA right now can say to the public, hey, we've got two conflicting orders right now. Right? Even if the order from Texas were in force, which it's not right now, they could legitimately say, what shall we do? We have two federal courts that disagree. And that's what we call the makings of a circuit split. The case from Eastern District of Washington is a long way from working its way up to the Supreme Court, in the sense that the last time I checked, a bunch of anti-abortion states were asking if they could intervene, and I think the district court said no, and I think they were appealing that to the Court of Appeal for the Ninth Circuit, and I'm not sure if they've issued a decision on that yet. I haven't watched while I've been traveling. But my point is that it will be a while before that case works its way through, but any justice on the Supreme Court knows that there is probably going to be a circuit split on this issue, and therefore they can't ignore it. So that's probably one of the reasons they took the case. There are also a lot of concerns in the drug industry in the US, because the argument that is being made by the plaintiffs and the judge from the district court in Texas is that, hey, years later, we can challenge the decision of the FDA. Even if it's a drug we don't actually use, we can make this very attenuated argument on standing and try to knock off drugs, right? For the pharmaceutical industry, that is really bad news, right? So I think there were a lot of reasons why I am personally hopeful that the Supreme Court will not go further down the path of restricting access to abortion care, that rather they will, in fact, either throw the case out on the basis that this crazy group of doctors doesn't really have standing, which would be an easy way for them to get rid of the case without diving too deeply into the other issues. But we'll see. But it certainly does put egg on the face of someone like Justice Kavanaugh, who so cheerfully said, we're never going to have to deal with an abortion case again. There are lots of other interstate conflicts that are coming. I won't spend too much time on this, but for example, a lot of liberal states pass laws. We call them sometimes safe haven laws, or laws to prevent their state government from cooperating with another state government that might try to prosecute a woman because she left the state and had an abortion in a liberal state. Believe it or not, there are some states that are trying to criminalize that. You left the state, you went to Illinois, you got an abortion, and now you're back, we're going to prosecute you. Again, Kavanaugh said in his opinion in the Dobbs case that any kind of restrictions on travel would, of course, be unconstitutional. But I don't know if Alito or Justice Thomas agrees with that. So we have a lot of interstate conflicts that are developing, and basically the Supreme Court is going to be dealing with abortion for years, despite what they said in the Dobbs case. So who suffers from the restrictions on surgical abortion care? And here I'm talking not just about the United States, but all around the world, because all around the world, women are learning how to access abortion pills. But poor women, women in developing nations, women who may not have access to the internet, essentially women in developing nations. And that's one reason I recently published an article on access to reproductive care and the Sustainable Development Goals. Because the truth is, one of the Sustainable Development Goals is to improve maternal health. One of the easiest ways to meet that Sustainable Development Goal is to get rid of really strict bans on abortion. A huge percentage of the abortions in developing nations are unsafe, considered unsafe by the World Health Organization now, and this is particularly true in developing nations with very restrictive laws. The other women who will be hurt by these bans on abortion are women with disabilities or health conditions that do not permit using abortion pills. There are some women who cannot take the pills. There are also women who want to be pregnant, but then suddenly in their second trimester, they develop a sudden health problem. And all of a sudden, the doctor says that it's not safe for you to carry this pregnancy to term. Well, those women, if they're in Texas right now or in Poland, they've got to get out of their jurisdiction to get an abortion, or maybe they wait until their condition is so severe that the doctor can say they're in a true state of emergency, that this pregnancy is going to kill them. But doctors, they hem and haw a lot in those situations. And one of the best examples was in Ireland in 2012, I think it was, when a woman who wanted to be pregnant and she had some medical knowledge, I think she was a pharmacist, she knew that she was in trouble and that she needed an abortion. And in Ireland at that time, it was legal for the doctors to perform an abortion if necessary to save a woman's life. But they hemmed and hawed and kind of, I don't know, is she really about to die? And then she died on the table. And the women in Ireland went to the streets. And that is why Ireland had a referendum and why now abortion is legal through 12 weeks with a 3-day waiting period. I think a lot of people never thought that would happen in Ireland. The other women who really suffer are women who receive a diagnosis of a fatal or very severe fetal disability. As long as the heart is beating in Texas, you cannot perform an abortion, right? And as I said before, the exception for a severe fetal disability was recently removed in Poland. So women in Texas have already sued the state of Texas over this. There are women also in Texas whose water broke at 18 weeks and they went to the emergency room. There's nothing you can do to save the pregnancy at 18 weeks. It's absolutely impossible. Rather than performing an abortion to preserve her health, in some of these cases, they've sent the woman home with her husband and said, monitor your temperature. When it gets up this high, come in. By that time, she's in septic shock, right? These are women who have already sued Texas. There's a group of 20 of them have already gotten a judgment. It's being appealed by the state of Texas. So we'll see what happens. But this is a long-winded way of saying that I do think the Republicans in the United States and the conservatives in places like Poland are actually going to regret this long-term, because what's happening is the women who they really wanted to target, healthy women in the first trimester of pregnancy, they're getting their abortions anyway, for the most part. The women who are suffering horribly are women in their second trimester who need an abortion for some therapeutic reason. So my last slide is to talk, kind of to sum it up in terms of the recent jurisprudence and where we're going. Right after Dobbs was decided, there was a lot of hand-wringing among legal scholars, not just in the US, but globally, saying, oh my God, this is the beginning of a trend. But I actually think the Dobbs decision will be seen long-term as an outlier. In fact, many state courts in the US have taken a different approach than the US Supreme Court. They've actually interpreted their state constitutions as protecting women's right to reproductive autonomy. Moreover, what we're seeing is that the Republican Party is taking a beating in the United States over this issue. And even, for example, in my original home state of Michigan, where the Republicans have typically managed to hold the state legislature recently through a lot of gerrymandering. Though we had a Democrat as governor, all of a sudden in the midterm elections in 2022, Michigan went all Democrat. And why? It's because there was also a constitutional amendment on the ballot protecting women's right to reproductive autonomy. Even some red states like Ohio, right, Kansas, we've seen the women come out to vote in favor of maintaining reproductive autonomy. So now that we also have the IVF issue on the table, I really think the Republicans are going to be hurt by this. And so long term, we're going to see, I think, more political support, ironically, for enshrining women's right to reproductive autonomy at the state level. I think it's also going to affect federal elections because despite what Kavanaugh said, women are smart enough to see that, well, this could come back to haunt us at the federal level. So, for example, some Republican senators have proposed a nationwide ban on abortion at 16 or 15 weeks. Donald Trump has recently indicated that he might support that, although he's smart enough politically to realize it's probably not a good idea, so he's trying not to say too much on it. On one hand, he likes to take credit for the overruling of Roe v. Wade. He did appoint 3 Supreme Court justices, which is unheard of in a single-term presidency. So he is responsible for it. But on the other hand, he's now watching what's happening politically and realizing that, we went a little too far, perhaps. Outside the US, we also see a lot of encouraging developments. For example, France recently voted, right, to enshrine women's right to reproductive autonomy. And we're also seeing some really interesting jurisprudence arising at the regional human rights level and the international human rights treaty monitoring bodies. Now, the European Court of Human Rights was one of the bodies that I examined in that very first book chapter I wrote, and I was a little disappointed to see what they were doing in 1992. At that point, the European Court of Human Rights was very much, well, this is one of those social issues. We leave it to the margin of appreciation. Every state kind of, you do what you want to do. But over time, the European Court of Human Rights has issued some decisions that, although they have not upheld the idea that a woman has a right to terminate, they have often interpreted certain rights, like the right to know, access to information, in favor of a woman who is seeking abortion care. RRV Poland in 2011 was about that, a case where a woman was not told the diagnosis of a very severe fetal abnormality, which might have led her to leave Poland to get an abortion, right? And so she was held to have had her rights violated. Increasingly, we are seeing a lot of cases coming from Poland to the European Court of Human Rights. They dismissed one case on the grounds that the plaintiffs couldn't show that they had actually been hurt by Poland's ban, but I think there are more cases coming. And I think at a certain point, the European Court of Human Rights is going to have to say, maybe there is now a European consensus, because apart from Poland and Malta, most parts of Europe do now recognize at least a right to abortion in early pregnancy. The Inter-American Court of Human Rights is a very interesting example because the American Convention on Human Rights is the one regional treaty that actually said that the right to life begins at conception. But increasingly, we're seeing jurisprudence from both the Inter-American Commission on Human Rights and the Inter-American Court on Human Rights that is holding the state accountable, at least in situations where women needed abortions because of health problems or because they were victims of rape or some circumstance like that. So again, not to the point of what Roe v. Wade said, but there is this emerging body of jurisprudence. We're seeing similar things in the treaty monitoring bodies for international human rights treaties. So the ICCPR is monitored by the Human Rights Committee. They have issued some decisions. I've just given you one example here, often in the context of cruel and inhuman treatment or punishment, right? Or right to life, if a woman is denied abortion care when she's been the victim of rape or when she has a traumatic health need. The Committee Against Torture has done something similar. It has actually recognized in its concluding observations on countries that an enforced pregnancy after a rape can be viewed as a form of torture to force a woman to carry that pregnancy to term. The CEDAW body has issued some decisions, like LCV Peru is an interesting decision, but they've also conducted an inquiry under their optional protocol into the lack of access for abortion care in Northern Ireland, which is very interesting because in theory, Northern Ireland is under the same legal regime as the United Kingdom, but in practice, it was impossible to get an abortion in Northern Ireland. And that is changing. If you look at the responses of the British government to that inquiry, they have definitely tried to make it easier for women to get abortion care in Northern Ireland. Finally, I'll just say the Committee on the Rights of Persons with Disabilities, it's been a really tricky issue for them because when that treaty was being drafted, there were people who wanted to put in a clause prohibiting disability selective abortion. It's a very touchy issue with the Disability Rights Committee because quite frankly, in some countries where abortion is very easy to get, the incidence of things like Down syndrome is very low. And so the Downs community sometimes views that as almost a form of genocide against them. And so this is a very touchy issue. But at the end of the day, the CRPD committee did issue a joint statement with the CEDAW committee in 2018 that really does support women's right to reproductive autonomy. They basically say they don't think there should be longer periods for legal abortion on the basis of disability. And I can see their point. If you look at, say, the British law right now, there's a longer period of lawful abortion if the fetus has a disability as opposed to other grounds for abortion. And I think the CRPD committee finds that quite offensive. But still, they are, I think, fundamentally on the side of women's right to choose. And I think that's essential. I've written a couple of articles about the practice of disability selective abortion. You know, and the truth is, you really cannot, I think, insist that a woman carry a pregnancy to term in that situation, because at the end of the day, it will be that woman and her partner who are responsible for raising the child. And if a child has a very severe fetal disability, that's a very harsh decision, I think. And it's particularly harsh in the United States. We had a number of states that even before Roe v. Wade was overturned, enacted state statutes prohibiting abortion when the reason for the abortion was a fetal disability. And some of those were being challenged when Roe v. Wade was overturned. And the ironic thing is that when the Republican Party in North Dakota adopted that statute, they were the first one. They also cut the funding for special education, what in the disability community we call inclusive education. So on one hand, we're not going to help you to raise a child with a severe disability, but we're going to force you to carry that pregnancy to term, which is sad. But that's where the Republican Party is right now. And that finishes my presentation. And sorry, I went a bit longer than I meant to, but I hope we have some time for questions. Thank you.
Thank you very much for this very sort of exciting overview and the recent development.